The following program is copyright protected under Title 17 of the United States Code. Any rebroadcast or other use of this program without the express written consent of the owners is strictly prohibited. Please take notice that if you infringe on this copyright, you may be held liable for any damages that result. Please take further notice that aside from possibly laughing, we intend to do jack about anybody's infringement. We're at the point where the music volume gets cranked and you hit the like and subscribe buttons because the following program is about to begin.
This is a Trump country. We live in the Southeast. We drink sweet tea. We don't drink socialist Kool-Aid.
We don't drink socialist Kool-Aid. That was great. Thank you, Joe. Good evening, everybody. Welcome to the fine program. I'm your host, Joe Nierman, a.k.a. Good Lawgic. Hope your day's been going really well. I have work to do tonight. I do have work to do tonight. I was reminded by my attorney, or technically Good Lawgic LLC's attorney, that there's like certain things I need to get filed and done on behalf of myself individually, Joseph H. Nierman, that he's not allowed to file, which means I need to draft a letter, and I'm going to walk you through exactly what I'm going to be drafting. I don't think it's going to take me like 4 hours. I'm praying it doesn't take me anything like that. I do have my beer ready over here. This is, if you're wondering, it's a Torpedo IPA. It's not bad. It's not bad. So I have that. And before I get into that, there's just one or two stories that I just wanted to cover, just because I see people talking about this stuff. And I know it's exciting to talk about certain things and sort of speculate, like, is Nancy Pelosi losing her marbles? Is Congressman Raskin inciting insurrection? What is happening in our world? What Democrats are losing it. But I'm going to cover each of those stories very quickly, and then I'm going to sit down and get to work, and I'm going to give you background as to exactly what it is, that in case you're relatively new to the channel. Also, I will tell you this, that the heart of my show, I am going to be spending time literally just working and letting you all watch me work with like the screen up, and you're going to see I've done this in the past. Some people seem to enjoy it, watching me work on this application. I filed back in April or so. I don't remember how long ago it is now. I filed an application to have Trump ungagged. Now, a lot of you are probably not worried about the gag because it doesn't seem like this is such a hot topic anymore, which is technically true. It's technically true. But the reason that I brought this application is much less about Donald Trump, much less about him and this particular gag than the gag order itself. And the notion that this gag order is now setting a trend for what will happen to criminal defendants across the country foreseeably for decades to come. We already see how the Justice Department has become so weaponized. And when they say weaponized, it tends to be weaponized against the right. Let's face it. It is weaponized against the right. So I filed this application because I think that the circuit court, specifically the DC Circuit Court's decision, where they approved Judge Chutkan's gag order, set precedent that is very dangerous, very bad, and it's been used in state court in New York because I'm a New York litigator, and I have litigated many times in New York, even though I'm not really a constitutional attorney or a criminal defense attorney or anything of that nature. I can understand what the Constitution says. I can understand what the constitutional precedent says. And my objective is to have that overturned. I'm going to get into that, and I'll explain it in more detail before I get into what it is that we're at and what stage we're at, my deadlines and things of that nature, so you'll all be up to speed. And you'll all understand exactly what it is that I'm doing before I pretty much tune out my audience and just get to work on getting my filing done, because I'm supposed to have that in by Wednesday. So We're gonna get that. I want to get it in tomorrow. Just gonna think about it. Anyway, so with that, let me cover a couple of things here real quick. First, let's talk about crazy Nancy Pelosi. A lot of people think that Nancy Pelosi lost her mind. A lot of people think she lost her mind because they saw her say this.
So he was in a good place to make whatever decision, the top of his game. Such a consequential president of the United States, a Mount Rushmore kind of president of the United States.
Mount Rushmore kind of president of the United States, talking about Joseph R. Biden. Mount Rushmore. It's not someone who goes down the annals of history as like a really solid. No, Mount friggin' Rushmore.
Want to know what comes next?
That he belongs up there on Mount Rushmore. Lincoln and Joe Biden.
But you got Teddy Roosevelt up there, and he's wonderful. I don't say take him down, but you can add Biden. So we have big needs for.
Anyway, so there you go. That was the whole clip there. Sorry,
the future of legal work is here.
They're going to give me the future legal work. I don't think they're going to do more work for me tonight. So, what the hell is happening here? What is happening? A lot of people see this and they're like, she's literally lost her mind. She's literally lost her mind. That's what people are saying. And I say, no. I don't buy it. I don't buy it. This is what I'll explain to you what's happening here. The Democrats recognize that they want to push forward Kamala Harris right now. So Joe Biden, during the last gasps of his candidacy, and his White House were working very, very hard to try and repair the damage that they inflicted on this country for the last 4 years, or at least how that damage was perceived. This was a very important point that Biden was trying to get across, to basically gaslight you the same way that many people have been gaslit, millions of people have been gaslit for decades about what Democratic policies are doing. So they just wanted to gaslight America and say, no, these 4 years, what are you talking about? It's been great. Let's talk about Bidenomics. Let's bask in Bidenomics. Now, would that have worked? I don't think so, especially when it's being championed by a guy who looks as if he's taken the wrong cocktail of medications. Whatever that cocktail is supposed to be, this is not it. So it seems as if that wasn't really working, but that had been his messaging. Now, Democrats, including that woman right there, Nancy Pelosi, shunted Joseph Biden to the side. They basically kicked him, and said, we're going to throw you out unless you withdraw from your 2024 campaign. So, and he said, we're going to just use 25th Amendment and yank you out of there. And you're going to lose. You're going to be gone in 2 weeks. You'll be out. So, with that threat, he caved. Now we have Kamala Harris here, his vice president. Her record, despite having a resume, which on paper sounds like she's accomplished, her resume as far as her political accomplishments is paper thin. So what they want to do is they want to try and make it seem as if Biden did a great job and Kamala Harris is responsible for that. Because they know that Trump is going to come out there saying they suck, it's been terrible, it's been a disaster. Look at your gas prices. Look at how disastrous your life is compared to what it was when Trump was in office. And it's a very powerful message. In fact, I want to share with you some new ads that they have, so Trump has, which are just remarkably powerful. Remarkably powerful. Let me pull that up for you now. These are Trump's new ads. Amazingly powerful. Look at this. It's powerful in how it's silent, literally silent ads, other than just hearing your standard everyday background noise with a little message in the corner. This is just powerful stuff. They're a series of 15-second ads, and this is the entire ad. Just gas price running, travel anxiety, courtesy of Kamala Harris. Next ad starts at 30 seconds. I mean, it's just amazing. It's amazing how a 15-second silence, because, and what I love about it is, you know, you're watching TV, whatever you're watching, and you're used to just hearing constant chatter of noise. The silence, with just like a low humming in the background, draws your attention. And everyone understands as soon as they see it, yep. It's just another reminder. Life sucks now. The economy sucks now. Thank you, Biden Harris. Anyway, so those are the 6 ads that they have. It's a great job, and the entire point is, you look at what Kamala Harris has done, latch her into Joe Biden, and look at how terrible it is. Look how terrible it is. Very, very powerful and effective ads. At least it seems to me. I would think so. Now, Nancy Pelosi comes along, and what does she do? Nancy Pelosi comes along, and her whole point is, we should put Biden on Mount Rushmore. Now, you come out and you react to that and you say, she's a lunatic. But this is all consistent with the notion of, no, the last 4 years has been phenomenal. It's been phenomenal. And here are all the bases that don't affect you on a day-to-day basis, but all the bases that we're going to try and convince you that Biden did a phenomenal job. So does that mean he belongs on Mount Rushmore? No, but the idea is, obviously, maybe you're going to argue with me, does he belong all the way up there Mount Rushmore? No, but the point being that, you know, he's a great president. There's another side benefit to this. There's another side benefit, and that is, I was telling you after Biden was forced out, I told you that the Democrats have a potential problem here, because if Joe Biden is mad at them, he can really mess up Kamala Harris. He can really, really mess her up. He can mess her up in a lot of different ways. Just offhanded remarks here or there about how ill-equipped she is. Just, you know, any sort of intimation that he gives that this was not democratic, this was not the right process, that he doesn't support, he doesn't think that she make a great president, is lethal. That she was a drag and harmful in the administration. Anything that he says. I mean, and let's face it, the dude's an old man. You don't know what he's going to say. He doesn't know what he's going to say 10 seconds from now. So he's a potential hazard. And I think what Nancy Pelosi told him is this. Retire, there was a carrot and a stick that they said to him, retire, and we are going to build your legacy and go out there talking about what a phenomenal, amazing president you were. And I think that that's what this was. That she's trying to build his legacy for 2 reasons. One, because it's helpful to Kamala Harris, And two, because it's a way of basically trying to placate Joe so that Joe doesn't go rogue on them, because nobody likes it when Joe goes rogue. Nobody. The Democrats are terrified of Joe going rogue. So they don't want to see that. And they know that if they sit there just fluffing him like, oh, you're amazing. Oh, so good. You belong at Mount Rushmore. And they do that for the next 4 months, 3 months till the election. Just completely, licking his face like a bunch of puppies. That he's going to want more of that. Of everyone talking about what a phenomenal president he was, how great his legacy was, what a great job Joe Biden did as president. So there you go. That's why she's saying it. She knows it's ludicrous. She knows it's stupid, but she's not insane. No, she's an evil, manipulative liar. That's what she is. We all know what she is. So I don't understand why people think like, oh my gosh, she's losing her mind. She's out of her friggin' mind. No, she's just a Democrat. And she's a very shrewd Democrat. She's a very intelligent Democrat. She's a very dangerous viper. And that's why she's talking in what she would say, after the fact, well, maybe that was hyperbole, but he did a phenomenal job. But the idea is if you start talking about like maybe he belongs up there, along the historic greats of America's past, then certainly you're not arguing about whether or not he's a disaster. He's a walking disaster. So that's what this is all about. That's what this is all about. She wants everyone talking about how she said this. That is doing her bidding. That makes her, even if they're arguing with her, she doesn't care about that. She wants it to be a conversation, because if it's a conversation, she's hopeful that it'll start making people think, oh, well, maybe he wasn't. Maybe he was a good president. That's what it's all about. That's all this is. That's all it is. It's full of crap, basically. That's my point. They threatened Justin Timberlake's turn the gag order the other day regarding his DUI. Really? Really? One of those little blue vests. Thank you for visiting Mount Rushmore. That'd be great. That'd be great. Anyway, so that's the story with that. That's the story with that. The other thing I want to talk to you about, told you, two kick stories. Two kick stories. See what else load here. Jamie Raskin. Charlie Kirk shared this. I don't know where he was when he said this. Jamie Raskin is the anti-Pelosi. When I say he's the anti-Pelosi, I'm saying this is politically stupid thing to say, what he says here. And people ask him about it. I was tagged on this, and people saying, Joe, what's he talking about? I think it was tagged last week.
What can be put into the Constitution can slip away from you very quickly. And the greatest example going on right now before our very eyes is Section 3 of the 14th Amendment, which they're just disappearing with a magic wand, as if it doesn't.
They're just disappearing with a magic wand.
Exist, even though it could not be clearer what it's stating. And so, they want to kick it to Congress. So it's going to be up to us on January 6, 2025 to tell the rampaging Trump mobs that he's disqualified. And then we need bodyguards for everybody in Civil War conditions, all because the 9 justices, not all of them, but these justices who have not many cases to look at every year, not that much work to do, a huge staff, great protection, simply do not want to do their job and interpret what the great 14th Amendment means. And I'm glad that Sherilyn's creating her new center so we can bring that.
Listen to this lunatic. This dude is a friggin' lunatic. Let's hear this last part. That we're going to basically keep him out on January 6th, and there's going to be rioting in the streets.
They want to kick it to Congress, so it's going to be up to us on January 6th.
Meaning, okay, so we know Trump's going to win the election. That's obvious. And then when he does win the election on January 6th, we in Congress are going to declare that he is ineligible to be president. after he ends up winning the election because we're deeming him to be an insurrectionist. And listen to this idiocy. What a complete Nimrod.
2025 to tell the rampaging Trump mobs that he's disqualified. And then we need.
He's so stupid. This is stupid on so many levels. This is like, it's almost like you would. I don't know where he is when he's saying this. I don't know where he is, but I have to assume that he's speaking in some giant elevator that's just going up and down, because this is wrong on so many levels. None of this makes sense. Nothing he's saying here is accurate. None of it is actually remotely viable. And in no way, shape, or form does this claim help the Democrats. This is just asinine stupidity. And I'm going to break down every little bit of the asininity, because I do think asininity is a word that should exist, even though it doesn't. And I'm going to break that. And after I break that down, I'm going to show you exactly just how utterly stupid this is from a logical perspective, from a law-based perspective, and from a political perspective. So give it to us, Jamie. Give it to us.
Bodyguards for everybody. And
we're going to need bodyguards from everybody after we declare him to not be eligible. Oh, is that the way you think it's going to work?
Civil war conditions
Civil war is going to be coming. Oh, sure. So we're going to need bodyguards for the Civil War.
Because the 9 justices, not all of them, but...
Yes, all of them. That's one of your first primary mistakes here. Yes, all of them. It's really not the first one. He's made several mistakes already. Trump won this decision 9-0. 9-0. There were 0 Supreme Court justices. There were 0 Supreme Court justices who thought that there was any legal basis to say that Trump can be removed from a ballot the way that they were looking to remove him. 9-0. 9-0.
These justices who have not many cases to look at every year, not that much work to do, a huge staff, great protection, simply do not want to do their job and interpret what the Great 14th Amendment means. And
what the Great 14th Amendment means. No, you see, what they said, and this is why you should not be worried about this. What they said was that you can't just declare all of a sudden. What do you wear to a rampage? Is there Kool-Aid? I don't know. I don't plan on rampaging. I think that there's literally less than 0 chance of this happening. Less than 0. They don't have the numbers. They don't have the numbers in the House. They don't have the numbers anywhere. I don't know where they think this is going to come up. They simply just don't have the numbers. Even if they wanted to try such a thing. B, the point being that the only way this could be effective is if Congress would pass a statute, which would govern how this whole thing, how the Section 3 of the 14th Amendment would operate. That's what the Supreme Court said. Not that you could just decide we're going to pick this guy and label him an insurrectionist. No. That is not what that case said. The case said that you have to have a statute which is actually being effectuated. And there is no statute. Congress has to write such a statute, and then that statute could only, under the law, apply going forward on someone who engages in insurrection. Meaning that if they had actually found some way to muster and cobble together enough votes to say this is what an insurrection is, they wouldn't be able to apply it to Trump, because that would be a problem of what we call in the law ex post facto. You cannot just apply something to someone retroactively. So you need to have a statute and then apply that statute to a particular person. And currently, there ain't no freaking statute. There used to be a statute, 2383. That got shelved by Congress decades ago. And now there's no statute. So what do you want? Go pass a law if you want to be able to apply the Section 3 of the 14th Amendment. That's what the decision said. Now, Jamie Raskin is trying to interpret this as saying, you know what they were telling us we're allowed to do? That if we don't like someone, we can label them an insurrectionist and then say they're ineligible to come in to serve as a president or as a senator or anything else that we want to say that they're ineligible for. No. You don't have that power. You don't have any of that power, Jamie. You got none of that power. So this thing that you thought they got wrong was not a handful of them. You said some of them got wrong. No, 9-0. All 9 of them said, no, this is stupid. You lose. No, this is ridiculous. But they also said, you got to have a statute. You ain't got none. If you ain't got none, so in that case, you got to write a statute. And if you wrote a statute today, doesn't make sense to say that this could apply after the fact, going back to now punish Trump, which I don't see how they would pass such a statute today. But you also can't apply it to an issue of habeas corpus to try and say we're going to apply it to this particular individual. No. So, and if in fact they actually tried doing this, I'll tell you this much. I am not just a little bit sure, I am positive the Supreme Court would be like, get the hell out of here. Are you out of your minds? Did you lose your minds? Because I'll tell you this much. The Supreme Court, did they chicken out in Texas versus Pennsylvania? Yes, they did. Were they cowards? Yes. 70%, 80%, 90% cowardice, 100% cowardice. Complete and total abject cowardice. There was literally like urine running. It's like they had to send out all the robes to the cleaners because the stench of the urine was just everywhere. Just everywhere. That's what Texas versus Pennsylvania was back in 2020 when they said, we don't have to hear this case. We don't have to hear this case. Terrible cowardice. So you might say to me, well, they hate Trump, so they might sit there and go along with it. No. See, the cowardice is this. The cowardice is they don't want to have 100 million Americans mad at them. That's what it is. They were terrified. So they said, okay, we're just going to stay out of this. It's just like, oh, you want us to you have an issue. You want us, the Supreme Court, the highest court in the land, the only court that's referenced in the Constitution. You want us to handle this? Well, we have to go over here. We have some very important stuff we need to take care of over here. So we're not going to deal with that now because we're busy dealing with these much bigger cases that are much more important. Cowards. Now, over here, they would be actually effectuating the will of, I don't know, whatever number of votes Trump manages to get. 80 million people? 85 million people? 90 million people? I don't know. If she does badly enough in the debate, maybe 100 million people. I don't know. But Jamie Raskin, he's like, oh, we're going to take over. There's going to be a whole civil war, and you're going to have to get the bodyguards and security because we're just going to say, no, not my president, not my president, not my president. That's what we're going to say, not my president. He's a congressman. This dude's a congressman. Oh, my God. Whew. Nimrod on a stock elevator, yes. Precisely, Pam. I'm literally 0.1 of a mile from living in Raskin's district. I've never been so happy my house is 0.1 of a mile from anywhere. He's in Maryland, right? That's where you are, Adrian? In Maryland? That's my recollection. Jamie deserved the big C. Is remission always bad? I don't want to wish ill on anybody. I don't want to go there. I think he's cockeyed. I think he's maybe he's not a serious individual. This was the guy who led impeachment. Guy's got such terrible TDS. Anyway, so yeah, don't worry about it. Don't worry about Jamie Raskin and his little civil war insurrection, whatever it is that he's planning, that he claims he's going to do with Section 3 of the 14th Amendment. But I should mention before I wrap up this story that this is politically stupid. Nancy Pelosi would never say something like this. She would never say something like this. Quite the contrary. She's very shrewd. She said stuff to try and actually, I don't know, help Democrats. Because what do you think this does? In what way? I'm sure when Nancy saw this clip, she's like, are you out of your freaking mind? Are you stupid? How stupid are you? How stupid are you? Because basically, you're daring America to vote for Trump. That's what he's doing. He's like, I dare you. I double dare you. I physical challenge you. You're not going to vote for him because if you do, we're going to keep him out of office. You think that's politically, that's your strategy to basically say, I dare you, America, to vote for Trump because we won't let him take office? See, Nancy Pelosi would never make a mistake like that. Never in a million years. No. Because it's just an idiotic thing to do. It's an idiotic thing because you're basically riling people up saying, who the hell do you think you are? You're going to tell me I can't vote for this guy? You're going to keep him out of office? No. I'm voting for him 4 times. I'm going to find 4 other people to prop up here. I'm going to start being the one to dig up corpses. So stupid. Every possible level. That's why I said wrong on so many levels. Politically stupid, legally completely flawed, and just as far as like logic and reasonableness as to what would happen just living in Candyland. Expecting Willy Wonka to come barreling out of the door wherever he is there. Basically say, ooh. No, I never saw Willy Wonka, okay? Sorry, I never saw it. Note to self, don't use analogies to things that you have no idea what they really actually are. Bunch of freaking Oompa Loompas. All right. I think that covered it. That covered what I had to. That definitely was those 2 stories right there. Covered it. All right. Let us now start to discuss my efforts to ungag Donald Trump, where we've been, where we're going, why we're doing this, what my arguments are, why my arguments are different from the arguments that Donald Trump made. I'm going to try and make this for you as simple as possible, and why this is a fight that you should care about. I apologize. It probably is, but I should put this up here while I'm at this. My name is Joseph Neerman. I'm a New York attorney, and I'm also a member of the New York City media. That's just who I am. I haven't put that banner up in a little while. It's been a minute since you all seen that banner down there below. The givesendgo.com/ungag Trump. Where I walk everyone through it, and you can see my initial papers there. I have them uploaded there in a web link. Now, in the case of New York versus Merchant, New York versus Trump, Donald Trump received a gag order, which he purportedly was found guilty of violating at least 10 times. 9 times, 10 times, somewhere around that. That gag order prohibited him from talking about any attorneys related to the case aside from Alvin Bragg himself. Anybody associated with the court staff aside from Judge Merchan himself. Any relatives of any of those folks. Not allowed to talk about any potential witnesses or even witnesses who testified. Not allowed to talk about anyone from the jury. This is similar to a gag order that was placed by Judge Engoron in the civil suits, which he ended up being found liable for $350 million or something, some crazy number like that. And it's similar to a gag order that was placed on him in the DC criminal action of United States versus Trump, where Judge Chutkan put a gag order on Trump. Now, when Judge Chutkan put that gag order on Trump, Trump appealed it. And in the decision, in the appellate decision, which affirmed Judge Chutkan's gag order, The D.C. Circuit Court cited a number of different cases. Landmark Communications versus Virginia, Shepard v. Maxwell, Nebraska Press Association versus Stewart. And they cited one Supreme Court case after another to try and justify the legitimacy of that gag order. And they said, look, here's all these cases which say, hey, sometimes you're allowed to infringe on First Amendment rights. In some emergency circumstances, you can infringe on First Amendment rights. And so they took those, and they would take a cherry pick, a line from here and a line from there. They didn't take the ruling. They weren't fixating on the decisions in those cases. They went through the different discussions because in each of those cases, with the exception of Shepard v. Maxwell, they ended up saying, no, you cannot infringe on First Amendment rights. I will point out to you that each of those First Amendment situations were related to freedom of the press. But they all stood for one firm principle. Almost never, ever, 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 ever infringe on First Amendment rights. The court should never, ever, ever do it. Ever, ever. And this is talking about First Amendment rights, freedom of the press. Freedom of speech is worse. So they took those cases and they say, these are the cases which teach us we are allowed to infringe on Donald Trump's First Amendment rights and gag him as a criminal defendant. Silence him while his witnesses who were testifying against him are going on podcasts night after night, making hundreds of thousands, millions of dollars, bashing him, bashing him, bashing him, bashing him. And we have a right to shove a gag in his mouth and shut Donald Trump up. And these cases, these Supreme Court cases, which go back to the 60s and the 70s, they tell us, these cases which all say, never ever do it. Don't do it, don't do it, don't do it, don't do it. These are the cases which tell us we're allowed to do it. So, when this DC Circuit Court said that, those same cases ended up being cited by Judge Merchan in the New York criminal proceeding, where there was a guilty verdict on 34 counts. Not a conviction, because he still has not been convicted. But when he was issuing a gag order, he used the exact same cases, the exact same principles that were purportedly found by the DC Circuit Court in the most backward, twisted, ridiculous decision imaginable. That DC Circuit Court decision is so terrible. It is such a gross misreading of Supreme Court precedent. It is astonishing. It is mind-blowing. It makes no sense at all. When Trump objected to the DC Circuit Courts, and he fought them, and he tried fighting this, and he tried fighting it in New York, and the applications that he made, the arguments that he made were very Trumpian. They were the type of arguments you would expect a Donald Trump to make. What do I mean when I say they were Trumpian? They were Trumpian, and when I say Trumpian, I mean in the worst sense, the least attractive elements to Donald Trump. Meaning, it was very much about me, Donald Trump. If you read through his arguments, these are not the strongest arguments to be made. They're actually fairly weak arguments. But he basically was saying, look, you can't do this to me because I'm running for presidential office. You can't do this to me because it's political speech. You can't do this to me because this sort of thing is stopping me. It's impeding me, and it's hurting my rights, my abilities to campaign. Are those arguments legitimate? I guess they are. There is legitimacy to them. They're just not very strong arguments. There are much stronger arguments because while it is true, it is true that the First Amendment, specifically with respect to speech, is designed to give the strongest possible protections for political speech. And the Supreme Court has said this over and over again. While it has said that, it's very unclear how that manifests. Meaning, okay, we all believe in freedom of speech. Now you want to say that has to be protected. Free speech has to be protected. Now you want to tell me this political speech has more protection. Okay, in what way does it have more protection than regular speech? Nobody really knows. Nobody knows. It's not defined anywhere. It just says this is the most protected speech. Okay. In what way can you point to a situation where we say, oh, we wouldn't protect this regular speech, but because it's political speech, now we're going to protect this and say you can't infringe on that because this is political speech? Nobody knows. Plus, when he's calling it political speech, while I personally agree with him, and you likely would agree with him, that most of the statements that he was making were political in nature, you start now getting into a whole subjective thing where it's like, okay, let's start looking at every comment he's making and start analyzing, is this political or not? And yes, I understand it's very easy to say that all these trials were by inherently political, and I definitely agree that they were 100% political, but that's certainly not what the judge who's looking at this is going to be saying, or the appellate court is going to be saying that this is political, these are political trials. So it's not a very compelling argument. You have to know who your audience is and say to yourself, is this a compelling argument to my audience? And considering the fact that whether you're going to the D.C. Circuit Court or even arguably to the Supreme Court of the United States, they might have, when you look at the way the court is constituted in the Supreme Court of the United States, you got 3 people on the right, 3 people on the left, and 3 people who believe in our institutions, including our court systems. So they're very likely to come to a conclusion. No, I don't know. I'm not going to come to an assumption that every charge against a politician or even Trump is necessarily political. So you're not making a compelling argument. And what's frustrating is there are much more compelling arguments, much more important arguments that Trump's team should have made. And I was frustrated that he did not make these arguments. So I decided to make these arguments. I came forward and I filed papers. Now you might ask yourself, what does this have to do with you, Joe? And the way I was able to find a basis to get in here and to have justification to raise his claims is because, as I mentioned at the outset here, I'm not just a New York attorney, but I am also a member of the media. I work for Good Lawgic LLC, which is the company I founded. And I'm registered as a member of the media working for Good Lawgic LLC. And I have freedom of the press. And I found a case in New York, going back to the 1980s, where New York said that if you gag someone on an important story, and the court issues a gag there, that can hurt the press. Because now they cannot collect information from a primary source. So if you wrongly gag someone in a case of significance in the media, that is a violation of freedom of press to anyone who wants to cover it. The case was New York Times versus Rothwax. And what you do is you actually file a proceeding in New York called an Article 78 proceeding. Most of the time when you see a lawsuit, you'll see it's like, I'm mad at you, so I'm suing you because you did this wrong to me. That's a civil suit. Or the people say you did a crime, so it's the people of the state of New York versus this defendant. Or if it's a federal case, the United States says you did a crime, so the United States versus this defendant. That's how you get your captions. So in this particular circumstance, in Article 70, where am I coming into a criminal case? Where's Joe Neerman or Good Lawgic coming into this? Well, the way the nature of the proceeding is handled in New York is in this Article 78 proceeding, I can sue Judge Merchan, the judge who issued the decision, and say, your gag order against Trump is unconstitutional, meaning it's a wrongful gag order. And since your order is wrongful and it harms me, that I have a right to intercede and say that should not be allowed to stand. And so it actually ends up being the case of Good Lawgic versus Judge Juan Merchan. You don't reference judge in the caption, but so that's why the name of the case is Good Lawgic versus Mershon. Now, under the rules of Article 78 that are brought down in CPLR, when you are suing a judge and saying, hey, judge, you issued an order that harms me, and I'm not in that case there. I got nothing to do with that case, but you issued an order that harms me. You go straight to the appellate division. The appellate division that would oversee that judge. So that case is happening in New York County, which is in the first department. This is part of the first department, what New York calls first department. So you go to the appellate division, first department. You go right past the standard basis. Normally, all cases, any case I've ever filed before in my life, you start off in Supreme Court. Because the levels of court in New York is there's one court of appeals, which is like the state Supreme Court. Instead of calling it the Supreme Court, we call that the Court of Appeals. Then there are 4 appellate divisions. And those appellate divisions are labeled first department, second department, third department, fourth department. So Manhattan is in the first department. So because this case is Manhattan, I go straight to that first appellate level, and I file a case in Article 78 proceeding of Good Lawgic and Joseph Neerman versus Mershon. Now, and that's what I did. What were the arguments that I made when I went in there, and how were they different from Donald Trump's arguments? Well, the arguments that I made there was really threefold. The first argument I said was that Judge Mershon engaged in a misanalysis of law. And the misanalysis of law that he engaged in was that he took these cases, these Supreme Court precedents, and he said, these Supreme Court precedents allow me to engage in a balancing test, where I'm balancing and seeing, is it fair to issue a gag in this scenario here? And it is true to a degree. I mean, I don't know that these cases talk about a balancing test. Some of them do, not all of them. Shepard v. Maxwell doesn't, but they talk about a balancing test. The problem is this. You don't just start off that you're in a balancing test, that every case is a balancing test. It's a balancing test. The point to a balancing test is you have something on this side and you have something on that side. And those are the two things that are balanced. So when these Supreme Court cases said sometimes we have a balancing test, what were those cases talking about? Those cases were talking about you have a criminal defendant. And that criminal defendant, when you look at these different cases, in that criminal defendant, you basically had that person had a right to a fair trial. And you had a media which had a First Amendment right. So you had, and the media, the way they were conducting themselves was so aggressive, so hostile to these defendants, destroying them, saying this guy's terrible, monster, awful, he confessed, he did it, he killed him, he's a terrible, terrible, terrible human being. And now the question becomes, does their First Amendment right, where they're saying all these terrible things about a defendant, trample on his Sixth Amendment right, or something, his 14th Amendment right, depending on what you're looking at, but his right to a fair trial, his constitutional right to a fair trial? There you have a balancing test. A balancing test, which almost always, the First Amendment wins. The only time the Sixth Amendment wins is when we say, look, this is a constitutional right, and your expression, your manifestation of the First Amendment right is so unfairly egregious, so unfairly hostile, that you literally crumbled this guy's ability to have a fair trial. You were so over the top, like Shepard v. Maxwell, for example, in that particular case. Picture this, okay? You got a defendant in a case on a murder trial where everyone in the country thinks he did it when he comes to trial. The newspaper boys is in the 60s, okay? So picture the courthouse in the 60s here, okay? Everyone's coming to court wearing their jackets and their hats, and they got their clipboards, and you got your little flash photography going every time a picture is taken with the big flash bulb there. And they're running in and out of court with the little notepad things, and they're running in and out of court there. And when they're running in and out of court, they're standing in the halls of the courtroom smoking during deliberations with the jury. And the court did nothing to stop this. So you got these media people who are coming out here and they're basically saying, and they're basically hanging out, having smokes with the jury in the middle of the deliberation, saying like, "Oh, you're totally gonna find him guilty." I mean, let's face it, the guy, you know, he butchered that family. You got to put him away already. How long is it going to take you before you convict him? The Supreme Court saw this and they're like, "How does the court not do anything to stop them?" from like talking, from interceding? And over here you have a First Amendment right which is literally crushing this guy. He had no chance of having a fair trial. So that's why in Shepard v. Maxwell they said, look, sometimes we have to have a balancing test and see, is it the First Amendment right, is it crushing another constitutional right, the right to a fair trial? That is the context of these Supreme Court cases, which all go on and on saying never step on First Amendment, never step on First Amendment, never step on First Amendment. Sometimes we'll have a balancing test where if the First Amendment is crushing another constitutional right, then we might curtail as limited as possible. We'll curtail First Amendment rights as small, as tiny as possible, just to make sure that this guy's constitutional rights not devastated. What's the balancing test there? Balancing test is First Amendment right, Sixth Amendment right, constitutional rights. Constitutional rights. That's your balancing test. And almost always the First Amendment right's going to win. What's the balancing test over here? Well, what they call is the fair administration of justice, meaning, well, the court's got to be able to conduct cases in a fair way. Is that a constitutional right? No, it's not. Now, the DC Circuit Court tried to imply that that's something that can sit on one side of the balancing test. The Sixth Circuit has said there's no such thing. That the state and the court, and by the way, Judge Merchan mistakenly went back and forth. Sometimes he called the state's interest in the fair administration of justice. What is, just so you understand these terms, what does fair administration of justice mean? It means that we need to have fair trials. There needs to be fairness in our trials. Now, the DC Circuit Court and Judge Merchan, when they were explaining this whole thing, they said, hey, look, we don't have fairness in this trial because when Trump goes out there and tweets, it's going to scare certain people. They're not going to want to testify. So now we're not going to have a fair trial. So we need to balance our need to have a fair trial versus his First Amendment rights. But that's not something any of the Supreme Court cases ever said were okay. The only time they ever allowed for a balancing test was when you had a constitutional right on both sides, not some sort of concept of we need to have fair trials. We are so worried about destroying someone's constitutional right that will, in some circumstances, as limited as possible, we will stop you from, we will curtail your First Amendment rights. What did they do over here, though? I mean, they don't have, there's no constitutional right. If anything, the constitutional rights were both on the same side of the ledger. You have Trump's the one who has a right to a fair trial. He's the defendant. You have Trump's freedom of speech. They're both on this side. Thunk. And on this side, you have some made-up concept of the state's interest in the fair administration, that the state has some sort of interest that trials be handled fairly, which is literally no such thing. There's literally no such thing. There could be such a thing as the court having an interest in having fair trials. And Judge Merchan sort of just waffled back and forth, sometimes calling it the state interest and sometimes calling it the court interest. But the point being over here that they basically were that they were saying someone has an interest in there being a fair administration of justice, but that's not enough in order to have a balancing test. The Supreme Court never allowed for such a balancing test. And if anything, there's this overarching principle of never, ever step on someone's First Amendment rights. The only time you have is when you have a balancing test. When's the balancing test? When you have competing constitutional issues. So the first argument I made there was a misanalysis of law. Is this something Trump brought up? No, he didn't. Now, why didn't he bring it up? I don't know. I don't care. But what I do care about is this. The DC Circuit Court's decision is not something that's just going to be about Trump. This is why this is still relevant today, even though, and I'll tell you, the gag is still in effect today. It has been curtailed a little bit. It has been modified a little bit, but it still is in effect today. And This is not something which is going to end with Trump. But this DC Circuit Court case is a precedent now. And it's a precedent that New York says we can rely on. And this precedent is garbage law. It's a complete misanalysis of Supreme Court precedent. Moreover, first, so that's the misanalysis. The misanalysis isn't saying that these cases allow us to engage in this test. The second argument is it's a misapplication of the balancing test. Meaning, because it's freedom of speech that's being threatened here, you have to show a compelling need, and you need to show that the remedy is as narrowly tailored as possible. How you establish it's a compelling need? What arguments did Jack Smith put up there to show that there's a compelling need? What arguments did Alvin Bragg show that there's a compelling need? That if Donald Trump, what's the compelling need? Let's understand what they're saying here. If Donald Trump speaks, people are going to be harmed. People are going to be endangered. People are not going to want to testify if Donald Trump speaks. Really? Okay. Let's think about this for a second. What's your proof of that? What's your evidence? Well, he sent out a tweet, and the next day about how this was an unfair trial. The next day, Alvin Bragg got all these people yelling and screaming that he's a terrible person, and they were saying all sorts of terrible racist things. Okay, he sent out a tweet. You know who else sent out a tweet? Ben Shapiro, Tucker Carlson. You know, Jim Jordan, New York Times, MSNBC, CNN. They're all tweeting. They're all sending out news stories, all talking about Alvin Bragg. So what makes you think that has anything to do with something Trump said? Well, he tweeted out Alvin Bragg's name 9 times over the last year. And over the last year, we had an increase by 800% of the number of terribly rude things that have been happening here. Okay. Does that mean it's because of something he said? Is there any causal link that shows he said something and 5 minutes later something happened to Alvin Bragg or people were particularly rude? No. They just said over the past year, there's been an influx. He started talking about it more, and there's been more rude behavior. So this is why we're afraid we're not going to have a fair trial. Are you out of your freaking minds? Half the tweets that he sent out about Alvin Bragg may have come after the behavior. First it was bad behavior, and later on he tweeted about Bragg. There's no effort made at all by Alvin Bragg to establish that anything Trump said actually led to a single bad conduct from anybody. From anyone at all. So even if you're allowed to have a balancing test, you still need to establish that there's a compelling need here, that he's the one who's the cause of bad results. And you need to establish that the remedy that you're implementing here is as narrowly tailored as possible. That whatever that we could maybe stop him from talking about this witness or about this type of testimony or about this type of scenario. You can say he can't talk about any person related to anything here. This is not narrowly tailored. It's the exact opposite of narrowly tailored. It's as broad as imaginable. And that makes it a violation of law. It's the same thing they did in Judge Chutkan's case. There was because in order to actually know that there was a problem here, they needed to have an evidentiary hearing. If you're going to infringe on someone's First Amendment rights, you want to tell me you can engage some sort of balancing test, you damn well better come with all the hard facts and the damn receipts and come in there and establish that absent this, some travesty is going to happen. Bring some freaking receipts. The judge said, the court in both D.C. and in New York both said, there are any receipts. And they say that things are bad. And Donald Trump didn't deny it because Donald Trump's like, I don't know what happened. So there's no hearing, there's no nothing. Nobody knows that any of these things actually had any relationship to each other, that he says something and then terrible results happen. But they just said, well, we think it is. Oh, okay. Well, I guess we got to now completely destroy this criminal defendant's First Amendment rights. Mind-blowing. I mean, it's mind-blowing. And so that was the second argument. First is there's a misanalysis of these cases don't say what you want them to say. And then even if they did say it, the way you handle it was effed up and screwed up. So I brought this application, and I also made a third argument that it was just grossly unfair, that he's silenced while these people who are coming out to attack him and potentially throw him in prison are poisoning the public by saying terrible things about him day after day after day after day after day after day, and making millions of dollars, and he can't even say anything in defense of himself. which is ridiculously unfair in the context of a criminal proceeding. It's just asinine. And I brought a temporary restraining order. I said, look, I need this relief right away. And they said, we're not giving you a temporary restraining order. And then they cocked around with me for a long time until finally they came back to me and said, we're not giving you relief. You lose. Now, along the way here, I initially filed this on myself, on behalf of myself and on behalf of my corporate entity, Good Lawgic LLC. Along the way here, I brought an attorney, a very base dude, very smart dude named Ron Baruti. Ron Baruti is now Good Lawgic LLC's attorney. I'd like to stay in their argument because I think that the way I present my arguments are more effective than I think anyone else I've ever heard talk about this. Well, my primary objective here is not to win in New York. I need to go through it in New York. And if I win in New York, that's, as I said when I started this case, if I win at when I first filed this, I said if I win at the appellate division, that is a win for the city of New York. If I lose at the appellate division and win in New York Court of Appeals, that is a win for the state of New York. And if I lose at the Court of Appeals and win in the Supreme Court, that is a win for the country. And that is ultimately where I likely have my best chances of actually winning. I am not expecting to find victory in the Court of Appeals in New York. I'm not. But my objective is that assuming I cannot get that relief here, that this is exactly the sort of argument that the Supreme Court likes to take. They like to grant cert on this sort of issue. They like First Amendment issues. They like issues that relate to gag. I'm telling you right now, this is exactly the sort of case that they seem to take one or two of these a year. And my primary objective here, the ultimate win, we get the Supreme Court to actually reject and say the DC Circuit Court's application here was wrong. And this is how I'm trying to get in there. This is my method to do that. And the reason I'm doing this again is not for Donald Trump, it's for you. Because if this DC Circuit Court decision is allowed to stand up, if this DC Circuit Court case is not ultimately reversed, this case will be used over and over and over and over again to say you're a criminal defendant. We need to put a gag in your mouth and shut you up. And if you open your mouth, we'll throw you in prison. And it's not going to be just someone who has 100 million, 200 million followers like Donald Trump. No, it's going to be people with 10 million or 5 million or 500,000 or 20,000 followers. That they can trump up whatever charges they want, and you complain about it, and they're going to say, oh, well, we got to throw you in jail now because you're a dangerous side. We can't have, it's the interest of fair administration of justice that we have to, now that we charged you with this ridiculously bogus, stupid, made-up crime, that if you talk about it anywhere, that we're going to throw you in prison for that, because otherwise justice is not going to be able to rule the day here, because people are going to act rudely to us. That's essentially what the DC Circuit Court came out with. And it's not going to finish with Trump. It's going to be here long after Trump is dead. And this is what I was trying to explain to a lot of people on the left. I don't care what the hell you say. What you can hate Trump till tomorrow and hate him to your dying day. But everyone of us knows that as of 2029, win or lose, Donald Trump is zero on the political landscape. Zero. He has no influence anymore. He can't do anything. In 2032, he's ancient history. But what will be here is this stupid, ridiculous, asinine, twisting, perversion, Frankensteining of the Supreme Court precedents that DC Circuit Court case that said, oh, it's totally okay for a court to just slap a gag on any criminal defendant they want because we're afraid about the state of the court's interest in the fair administration of justice, which is complete and total crap. And that's what I want Supreme Court to say, no, nine. And that's why I'm doing this. And if you're interested in supporting this, I will tell you, come to my website, which is givesendgo.com/ungag Trump. right there. And the link is down in the description below. It's scrolling over here in the little banner. Anyway, where am I at as far as work I need to do tonight, and what is that about? Now that I gave you the entire explanation as to what it is that this case is about, what is happening with this? Well, we followed the Court of Appeals. The Court of Appeals sent us a letter. It says this. Sent to me and Ron Baruti. Dear Mr. Baruti, this is my appellate number here, my Court of Appeals appellate number 2024-00088. Dear Mr. Baruti and Mr. Neerman, the court has received your preliminary appeal statements and will examine its subject matter jurisdiction with respect to whether a substantial constitutional question is directly involved in support an appeal as of right. Now, what is the deal here? What is happening here? Do I automatically go to the Court of Appeals? Am I automatically allowed to go in there and have them listen to my arguments? Well, the CPLR spells out that if it's a matter of constitutional question, interpretation of constitutional law, you're allowed to that, and you lose at the appellate division, you can come to the Court of Appeals as of right. Most scenarios where you lose at the appellate division level, you need permission to argue before the Court of Appeals. That's why, even though there are thousands of cases in the appellate division, we're in July here, and this case is number 88. Because most cases don't get that. There's always a winner and loser, but most cases don't get that. I am technically not even there yet. Because I said that and Ron Baruti following on behalf of Good Lawgic LLC argued that we can come in there as of right. We're going to pull up that statute in a little bit. And the reason we come in there as of right is because I argue under state law, which the New York State Constitution has freedom of speech, which the Court of Appeals has said is even broader than the federal counterparts. It's broader than the First Amendment. It's more protective. So the question is, you're now relying on Judge Chutkan and the DC Circuit Court and what their interpretation of the First Amendment is. How are you relying on that to say that's okay when Judge Merchan has to apply New York state law? And that's a higher yardstick. So this is an interpretation of New York State constitutional law, Article 1, Section 8, which is the one that protects freedom of speech and freedom of the press. So, let me just get to a couple of these chats here. Spuds gifting the 5 Good Lawgic memberships. God bless you. Why don't I hear that? Where's my soundboard? I don't know what's going on. That's weird. I don't hear my soundboard. I'm sorry about that. God bless you, Spuds. Thank you so much. Coke kind of. Okay. Thank you, Joe Neer and Collection Company. Jen's a trader. Can we revoke citizenship soon? Yes, she is. Terrible person. This grocery pack, Trump should do it. Trump should do it. Do it. I don't want him to do it. Let's just stop it. Stop the madness. Stop the madness. All right. You should file within 14 days. So this letter was dated July 24th. this a little narrower. So the court has received your preliminary statements and examined its subject matter jurisdiction, whether with respect to whether a substantial constitutional question is directly involved to support an appeal as of right. An appeal as of right. This examination of jurisdiction shall not preclude the court from addressing any jurisdictional concerns in the future. You should file within 14 days of July 24th, after this letter's date, your comments in letter formats. So that's why I'm writing a letter tonight. This is what I'm working on. Justifying the retention of subject matter jurisdiction, the jurisdictional response. By copy of this letter, your adversary is likewise afforded the opportunity to submit a jurisdictional response within the same 14-day period after this letter's date. So we're all submitting our arguments as to whether or not we come in here as of right. All letters shall be filed proof of service of one copy of the letter on each party. So I got to have, yikes, that was bad. Proof of service of one copy of the letter. If applicable, a disclosure statement required to be filed by corporations and other business entities pursuant to Section 500.1F of the Court of Appeals. Rules of practice shall be filed. That's not me. That's on Ron Baruti to do for Good Lawgic LLC. That's not relevant to me. So this part we say, I don't need to worry about this. The times within which briefs of the marriage must be filed are held in abeyance during the pendency of this jurisdictional inquiry. If this inquiry is terminated, by the court, the clerk will notify counsel in writing and set a schedule for the perfecting of the appeal. So when you file a notice of appeal, perfecting the appeal is when you write your brief and submit a copy of the record as to all the papers that were submitted there. This communication is without prejudice to any motion any party may wish to make. Parties are also required to submit digital versions of each paper filing. See sections 500.2, 500.10, the rules by uploading them to the Court of Appeals companion filing upload portal for civil motions, and Rule 500.10, jurisdictional responses. The portal access through the court's website. The appellant shall upload a digital version of each brief filed by each party in the appellate division. Appellants also shall upload, we are the appellants here, a digital version of each brief filed by each party in the appellate division and a copy of the record or appendix filed in that court. The document contains technical specifications and instructions for companion filing upload for the portal. This I blocked out here because they tell me this is my PIN number. And they say PIN numbers should not be shared with you folks, with others who are not parties to appeal. All companion digital filings must be submitted no later than the due date for the jurisdictional response. And then they tell me I have to give it a specific name on the file. So I guess this is what I'm supposed to call my file. Matter of Good Lawgic, Beamer Shan, App Nearman, Juror Response, PDF. See, he called it this, the Good Lawgic, because he's serving for them. I'm doing it for myself, the Nearman one. Okay. Appellants also shall file the PDF file naming conventions with respect to the digital submission of additional materials. What do you want from me? What am I supposed to do? I don't know what I'm supposed to do. Okay. So first I got to write me a letter. Then I got to call it that file. Then I have to serve it on my adversaries and have a proof of service. Now I also got to upload digitally the other stuff. And all digital materials shall be submitted in separate files. Response to, okay. Contents of digital submissions must be identical to those filed in hard copy. So it's just to serve by hard copy also. Okay. If I have any questions, I should call Margaret Wood. or Edward Ohanian. They've been very helpful. When I talked to them, they were very, very helpful. Very, very nice. So now I need to basically put in a jurisdictional response, which is explaining why we have the right to appeal as of right. That's the letter. That's my homework assignment. Okay. Let's see what Ron did so far. This is his. How many pages is this? Jesus, 4 pages? 5 pages? Can I steal some of his work? Can I steal some of his work? The question is, how much of his work can I steal? Definitely some of it I'm going to be stealing. Let's see what he wrote. First, let me convert this to Word. Okay. What do you want me to call this file? We'll just all right. Let's see what he did and how much of this I can steal. Good lawyering means knowing what you can borrow. So, first we're this firm represents Good Logic LLC. Let me read through it first, and then we'll see what I should do here. Then I'll see how much I can use and how much I want to add it. His firm represents petitioner Good Logic LLC herein. Please accept this letter in response to this court's correspondence of July 2024 seeking justification for the retention of subject matter jurisdiction on this matter. Please accept this in response to the same. Okay, so we're going to have this. As what's with the formatting? What the hell happened here? Sequel 5601 provides that an appeal may be taken to the Court of Appeals as a right from an order of the appellate division, which finally determines an action where there is directly involved in construction of the Constitution of the state or of the United States. Appeals Court of Appeals has a right. An appeal may be taken to the Court of Constitutional Appeals. An appeal may be taken to the Court of Appeals as a right from an order of the appellate division, which finally determines an action where there is directly involved in the construction of the Constitution of the state or the United States. Appeal may be taken to the Court of Appeals as a right from an order of the appellate division, which finally determines an action where there is directly involved in the construction of the Constitution of the state of the United States. Okay. This is called defining a term. Technically, Good Logic LLC. Now I can leave the. Now when I leave the out, once you define it by having capital letters and quotations, every time I say Good Logic, it actually means Good Logic LLC. Competition with the appellate division seeking to protect. Let's do this one. Yeah, what happened there? Why does this look weird? This is the problem with full justification. Everyone says full justification. Then I see words that look like this here, and I'm just like, I don't know what we're supposed to do with this. It just looks stupid. Almost like it looks like almost an acronym with the word unconstitutional. So, kind of fun. I'm pulling up another file because I want to track some of the language. That's what I wanted. Appellants, members of the New York press, argue that such order violated appellants' news gathering rights under the New York Constitution, the First and 14th Amendments of the United States Constitution, as well as President Trump's free speech rights. Yeah, I'm going to have to tie into the free speech rights because that's how I don't get in here unless his free speech rights have been violated. So appellants, members of the New York press argue that such order violated appellants' news gathering rights under the New York Constitution. I know I said I was going to read this before I started editing it, and when I read stuff, I can't help myself from doing the editing thing. But I'm going to actually read through the rest of this now. So let's just do that. Let's get that out of the way. You know, it's funny you say that. It's the exact same keyboard. I actually brought the keyboard with me. It's the exact same keyboard, but I got so self-conscious during my prior mukbangs that like I think I naturally just started typing softer. Yes, capital letter names are magic, Allegan News. They are magic. All right. The appellate division entered a final order dismissing Good Lawgic's petition and failed to substantively address Good Lawgic's arguments on New York and the United States constitutions. Instead, it relied on a decision of the U.S. Court of Appeals for the District of Columbia ruling against Good Lawgic, which decision Good Lawgic argued did not comport with either the New York or United States constitutions. For instance, the appellate division failed to analyze Good Lawgic's challenge to gag order pursuant to Article 1, Section 8 of the New York Constitution, which provides every citizen may free speak, blah, 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 as this court eloquently detailed in Immuno AG, which Good Lawgic raised. We have much broader protections here in New York than people have under the First Amendment. Good Logic argued that under the New York Speech Clause, the appellate division was compelled to apply the most liberal protections available to President Trump for the benefit of Good Logic as a member of the press, since the First Amendment is the bare minimum of protection afforded by the New York Speech Clause. More specifically, Good Logic argued that under the New York Speech Clause, the appellate division should have applied the decision of the Sixth Circuit Court of Appeals to the issue which held that it is individuals, not the government, to whom First Amendment interests attach. To the extent that publicity is a disadvantage of the government must tolerate it. The government is our servant, not our master. Thus, the Sixth Circuit gave robust First Amendment protection to the criminal defendant's speech, the first free press's right to report it, which is in keeping with the broadest protection of the sensitive role of gathering and disseminating news of public events. So I want to insert here. So I'll explain to you what I'm making a note to myself about now. If I skim through this paragraph here, this is from a New York Court of Appeals case. Again, Court of Appeals is the highest court in the state of New York. What New York, in this Court of Appeals case called Immuno AG, what the court said was that first and foremost, the First Amendment is not where New Yorkers get our freedom of speech and freedom of press, because you have stronger protections under the New York Constitution, because the New York Constitution gives the broadest possible reading of First Amendment rights. So the question is, and this is something I discussed with Ron Baruti, what does that mean when you say, okay, so First Amendment is obviously pretty powerful in general. This governs all Americans, and that's protecting your freedom of speech and freedom of the press. Okay. New York has the broadest rights anywhere on the planet, according to themselves. That's what they say. If you're going to say that we have the broadest possible and the consistent tradition of this state providing the broadest possible protection of sensitive role gathering and sending news of public events and safeguard the free press against undue interference, what does that mean? Like, how does that? So that's what when I was telling Ron this, I was like, we're the broadest yardstick available. And he goes, well, how does that translate though? I mean, just because something is broader, I mentioned 45 minutes ago, I was talking about how political speech is the most protected speech. What does that mean, most protected speech? What would you protect because it's political that you would not protect if it was not political? It's very hard to come up with an answer for that. Similarly, Ron was challenging me by saying, just because New York has the broadest protections, how is that any broad? In what way can you say that that's broader than First Amendment? So I said, as a bare minimum, if you're going to say that New York has the broadest, strongest First Amendment protections, that means that if there is a jurisdiction in this country which says we're going to protect First Amendment Another jurisdiction which interprets and says we are not going to protect because we apply the broadest, strictest standards, we must, in New York, attach the stricter, more protective First Amendment standard. So on issue A, it may mean that we follow the Third Circuit. In issue B, it may mean we follow the Seventh Circuit. Over here, there's a conflict between the Sixth Circuit and the DC Circuit. The DC Circuit is more protective of First Amendment rights. DC Circuit is not as protective. Because New York purports to hold itself out as applying the broadest possible protection of First Amendment protections, you cannot go with the lower protective yardstick of the DC Circuit Court. You have to go with the Sixth Circuit's higher protection standards. Otherwise, New York is not the broadest place. The Sixth Circuit is broader than us. That's the argument I made. And Ryan was like, that's a really good argument. I like it. I like it. So that's what I plan on explaining down over here. Because it's not an argument I've seen anywhere. That's something I came up with philosophically, what makes sense. But it's not spelled out anywhere. And I do think it would be a massive win if I can get New York to embrace that philosophy. And it's a logical interpretation. It's a logical application. They already set down the high and lofty words. I'm giving those words meaning. I'm giving them an opportunity to give those words meaning. Instead of applying such broad protection, the appellate division relied on much narrower and less protective decision of the United States Court of Appeals for the District of Columbia with respect to the gag order issued against President Trump in the criminal action pending against him in the U.S. District Court in D.C. Such Court of Appeals decision applied a balancing test, should be said. Court of Appeals decision applied a balancing test essentially between President Trump's First Amendment free speech rights versus the prejudices to the trial purported prejudices to the trial. Not only such tests applied by the appellate division in conflict with the Sixth Circuit's view of the First Amendment in such circumstances, but it plainly is not in keeping with the consistent tradition in this state of providing the broadest possible protection of the sensitive role of gathering and sending news of public events. He did a good job of expressing this. I like this, which is the standard applied by New York Court of Appeals pursuant to New York Speech Clause. Indeed. Appellant asserts that a gag order violating long-standing United States Supreme Court First Amendment law as well. Regarding appellate review of gag orders, the United States Supreme Court has reiterated time and again, we have held that in cases raising First Amendment issues, an appellate court has an obligation to make an independent examination of the whole record in order to make sure that the judgment does not constitute a forbidden intrusion in the field of free expression. Such a great quote from a case that they cite this case. They cite Gentile versus State Bar of Nevada. And they completely, to the extent that it bothered them, they ignored it. The appellate division did no such thing in dismissing Good Lawgic's petition. It's really in Finally, the President Trump was first amendment and New York speech clause, right, to speak with the press about the conflicts of interest that Judge Merchan had respect to both his daughter and wife's professional dealings. See, he always comes back to this thing. This is something that, and this is where you have personal flavor versus like where do I want to hit versus where do I want to stress, where don't I want to stress. And it's not to say that he's wrong. He's completely correct that Judge Merchan silencing any conversation about his daughter was just completely ridiculous. Because, I mean, we didn't know at the time how big the number was. It turns out $12 million she's gotten from the DNC this year. This year. By depriving President Trump's First Amendment and New York speech clause right to speak with the press about the conflicts of interest that Judge Merchan had with respect to both his daughter and his wife's professional dealings. Appellants argue that the gag order violated President Trump's right to a fair trial pursuant to the 6th and 14th Amendments of the United States Constitution. Appellants assert that such conflicts of interest related to financial conflicts within 6 degrees of trial judge required Judge Merchan's recusal pursuant to 22 NYCRR. And Code of Judicial Conduct. By silencing President Trump from discussing such conflicts with good logic and others, President Trump was deprived of fair trial. Presidential impacts on personal affirmation of the terrifying New York. Essentially, Taylor will be required. No evidentiary will be required to provide those a compelling need to depend on such defense for American constitutional right. No Taylor required to um, I only visited here. I guess that's okay. I'm not crazy though. This house is no special constitutional law. Visited a court. You know what? Let's do that. You did a really good job. You did a really good job. Okay. Now let's start addressing formatting issues. Oh, Matt, you're awesome. God bless you, brother. Thank you so much. Do this in course. I might have this up individually. How would they reference it? Matter of good logic versus Moshe. That's what I call it. Let's look at code changes. Let's go. Really? Not half myself individual responsible courts request by correspondence to July 24, 2024 regarding the above reference now. This is like watching myself works making me miserable. I want you to know something. It's an interesting thing. Like I feel like when people are watching me, I don't know why it keeps me like moving. I hate moving. I hate it. But it's sort of it makes me feel like okay, this is not. I'm not doing this for me. Like I'm no more of a beneficiary from any of this than any of you are. But it just sort of keeps me like pumped. Otherwise, like if I'm sitting like in my own desk on like 8 hours ago, if I come here, sit here, and start doing this, I'd be sitting there just like hating this. Like I'd be like, oh, Jesus, stupid mother now. But it's like now I feel like okay, but this is part of my work, so you all get to see the sausage roll. That makes sense. You did not. Oh no, you didn't. Oh no, you didn't. Check that. It's just not true. It's just not true. Write on behalf of myself individual response to the court's request via correspondence of July 24, 2024 regarding the above reference matter. Please consider this appellant's justification. CPA 56.1b1 provides that an appeal may be taken to the Court of Appeals as a right for the order of the appellate division, which determines an action where there is directly involved in the construction of the Constitution of the state or of the United States. Appellants. Appellants file petition with the Appellate Division First Department seeking to protect our rights as members of the complaints. Specifically, Justice Juan Merchan's unconstitutional gag order entered against President Donald Trump. People standing here up was Donald Trump and this member of someone in a criminal trial. Had the perceivable impact of wrongfully infringing appellant's rights of freedom of the press and your Constitution. Trump's saying, President Trump was prohibited. From freely communicating with the press. See, why does it look so jumbled? It looks so condensed. Why is it doing that? I hate when you see it. Look at this. These three words, all of a sudden, it's like, I don't know what the hell's happening here. Like this. Let's see. If I change this to non-justified, it still is looking stupidly compressed. I don't even know why that happens. I'm going to sell the coins. The coins will be sold. I'm going to sell. I know I'm holding coins. I got bigger fish to fry tonight, brother. Why the hell is it doing that? Can any of you explain to me, someone, just explain to me why this would be like this? You see how it all looks like it's just sort of like every letter's on top of each other? Why does it do that? I didn't change. I didn't hit anything. I didn't change anything. I don't know what kerning is. Kerning? It's called kerning? Is that what it is? Kerning? I don't have a choice on a font. No, you can't just pick whatever you want. You have to go. This is like New York Times New Roman is like size 12 is like standard in the industry. If I pick a different font, I might as well. If I use a different font, they will think I'm. They'll look up and see if I'm actually admitted to practice law. That's how unusual it is. They'll be like, "What are you? We're going to bring in a crayon next?" I never even heard of kerning. You know what? Maybe if I change this to 14 point. Still looks condensed. There's no space between the A and the N. They're just sort of like on top of each other. You see, look how the A and the N are just literally on top of each other. It doesn't even matter what size I make it. Look at this. They're literally there's like more space between this A and N than there is between this one, even though it's much bigger. This doesn't make any sense. Something's These are all the same font. You see how up here it says Times New Roman 12? These are the sort of things, by the way, if you want to know what's really sad, if I was not on camera right now, everything I'm saying right now, I would still be saying these exact same words. Why is it doing that? Jesus. Why? This looks wrong. This does not look like the same font as this. They're both Times New Roman 12. This is the stupidest thing in the world. Look how much bigger this looks. Appellants and or I beat you, Kerners. I beat you, sons of copy and paste it. Oh, man. I'm going to go back and change my unconstitutional. Just. The only problem is changing the spacing to make the margins even line up on the page. Well, I fixed it. I just have to copy and paste it from elsewhere. I had the same word and copy and paste it. Okay. Now this space looks wrong. This space looks bigger than this space. What's this format? That's 2. And then double. What's 2 versus double? This is. No, that's not right. Something's wrong here. This doesn't have anything this spacing before. Justified outline level, double, 0 point. That's what I want it to look like. What do you have? Something's wrong. Can't worry about that, though. All right. Further, appellants collaterally attacked the gag orders on grounds that they violated President Trump's 6 and 14 areas. And President Trump was prohibited from freely communicating. I don't like freely. That's wrong. That doesn't look right. The appellants enter the press about Judge Bush and his wife. And The appellate division entered a final order dismissing Good Lawgic's petition and failed to substantive. Appellants. Appellate division entered a final order dismissing appellant's position and never substantively address their arguments under New York and the United States Constitutions. Instead, departments rely on a decision of the U.S. Court of Appeals for the District of Columbia ruling against appellants. This did not comport with either the New York or United States Constitutions. For instance, Appellate Division failed to analyze Good Lawgic's challenge to the gag orders. For example, Appellate Division failed to analyze appellant's challenge to the gag orders pursuant to Article, which provides every citizen may freely speak, write, and publish his or her sentiments on all subjects, being responsible for the use of that right. No law should pass to restrain the liberty of speech or press. So all criminal prosecutions or matters libels, the truth may be given in evidence to the jury. And if it shall appear to the jury that matter charged as libelous is true, and which is published, partially acquitted, and the jury shall have the right to determine the law and the fact. Why are you putting this in here? Take this part out. No one cares about this part. That's impertinent parts. Expansive language in the New York State Constitution is far broader than its subsequently authored counterpart. This is too close. I don't like the spacing here. Spacing is just... The expansive language in the New York State is far broader than its subsequently authored counterpart. So, the First Amendment. Its expansive language in the New York State Constitution is far broader than its subsequently authored counterparts set forth in the United States. Appellants argue that under the New York Speech Clause, the appellate division was compelled to apply the most liberal protections available to President Trump for the benefit of appellants as members. Under the experience. The New York Speech Clause, as interpreted by this court, obligated a decision of the Sixth Circuit Court of Appeals to the issue. The Sixth Circuit held that it is individuals, not the government, to whom That's really the approach of the Sixth Circuit Court of Appeals to the issue of bar. The Sixth Circuit held that it is individuals, not the government, to whom First Amendment interests attach. To the extent that publicity is a disadvantage for the government must tolerate it. Take it on the chin, suckers. Eat it, government. Government's our servant, not our freaking master. Thus, the Sixth Circuit gave robust First Amendment protections to criminal defense speech, and the free press's right to report it. This court has directly expressed that freedom of press speech protections speech protections for freedom of press speech reached their zenith in New York. There's no other. How can how can New York afford weaker protections to freedom of speech press than the Sixth Circuit? If New York State latches on to interpretation of the Constitution law. To attach weaker protections to freedom of speech based on the circuit. If New York State lacked interpretation. Nevertheless, New York should be proud of this court's dedication to interpreting our state constitution as the benchmark in protecting fundamental civil liberties. If New York embraces this protective approach toward the circuit the District of Columbia, Is this too much? If New York embraces the less protective approach, let's argue. Appellants argue that if New York embraces a less protective approach employed by the D.C. Circuit Court, its noble promise of broader protection would seem like empty. Read as empty words, lofty ideals that have no practical effect. Accordingly, I need another word for noble. Thesaurus. Do you have a thesaurus in here? Is that thesaurus in here? Instead of attacking the court, let's brown nose him. Brown nose the courts. So it is a noble idea. I actually believe it. So if I can brown nose in ways that I actually really believe it, why not? No, I'm just going to go with thesaurus. Really? Gentle, imperial, patrician. What? No. Benevolent, brilliant, charitable, dignified. Dignified. Ooh, I do like dignified. Virtuous is not bad also. I don't use lofty. Virtuous is probably the best one. Worthy, august. August. No, it's not August. It's August in this context. Oh, I like that. Appellants understand this court's noble recognition broadest protections as mandated. Whereas Balance understands, of course, no recognition of broad to is the end of that. Whenever there is a split in interpreting whether First Amendment rights may be infringed, your promises to embrace whichever approach is most committed towards protecting individual civil liberties. I like it. I like it. I like it. Oh, what's going on? What that? Currently, Pounds understands, of course, no recognition of broadest protections of civil liberties, mandating that whenever there's a circuit split in interpreting whether First Amendment rights may be infringed, New York promises to embrace whichever approach is most committed towards protecting the individual's civil liberties. In this instance, that is the interpretation embraced by the Sixth Circuit, and not the D.C. Court. Instead of applying such broad protection, however, the appellate division relied on much narrower. I'm going to accept this. Agree. Accept. Must protect us in the United States with respect to. I called this criminal trial, right? That was what the term I used. I did. Oh, this is a different thing. This is a different case. Much criminal action against me with district court in D.C. Said Court of Appeals decision applied a balancing test essentially between Indeed, appellants assert that the gag orders violated longstanding United States Supreme Court First Amendment law as well. Good, 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 good. The appellate division in granting the gag orders, dismissing appellant's petition. Plural. Finally, by depriving President Trump his First Amendment of New York speech clause right to speak with the press about the conflicts of interest that Judge Raskin had with respect to both his daughter and wife's profession. Let's argue that the gag order will accept this change. Gag orders violate President Trump's right to a fair trial pursuant to the 6th and 14th Amendments of the United States Constitution. Appellants assert and accept this. Such conflicts of interest related to financial conflicts within the 6 degrees of trial judge. Which we heard here. Must require Judge Mershan accusal. Moreover, the precedential impact resulting from affirmation of Judge Mershan's gag orders should terrify me. If we understand any criminal defendant who has any every criminal defendant who has any type of social media platform can and invariably will be silenced. No evidentiary to insulate the court from perceived threats to the fair administration of justice. No evidentiary hearing will be required to provide that there is a compelling need to infringe on said defendant. No time will be required to ensure that the infringement is as limited as possible. The lower courts have misanalyzed and misapplied New York. If permitted to stand, every criminal defendant has any type of social media platform can and invariably will be silenced to insulate the court from a perceived threat to the fair administration of justice. No evidentiary as with Trump, no evidentiary hearing will be necessary. Better to provide, establish. Misanalyzed and misapplied New York and the United States constitutional law. Their error perceivably harming Poland's freedom of press rights. Misanalysis and misapplication of constitutional law in Donald Trump's criminal trial dangles like a sword of Damocles over the head of every New York criminal defendant. This can only be is jeopardy. This unfair and unconstitutional jeopardy can only be put to rest by this court. Based on the foregoing appellants, The second appeal is a right pursuant to CPL instance that you withheld. Good to go. Well, no, let's take this out. That's not how I spell my name. Silly goose. You silly goose. What's it? What's it? So it's going to be back on. Design layout. Wrap text. Text. What the heck? No. Get out of here. Get out of here. Get out of here. Move, bitch. Get out of here. Get out. All right. I think we're good. I really should do another read, right? I should do another read just to make sure that I didn't miss anything. It's the Court of Appeals. It's the Court of Appeals. This is like, you're not really dealing with the Court of Appeals on a regular basis, right? It's the freaking Court of Appeals. I know I need to change this, but I'm going to change this when I get offline because I'm not doing that in front of you people. So I'll change that. That's not a problem. Don't worry, I'm not going to use his letterhead. Dear Mr. Coors, I am writing on behalf of myself individually in response to the court's request via correspondence of July 24, 2024, regarding please consider this appellant Newman's justification the court's retention of the subject matter jurisdiction of this matter. CPLR 56 provides that an appeal may be taken to the Court of Appeals as a right from an order proposition finally determines an action that is directly involved in the construction of the Constitution of the state of the United States. Please let state should be capitalized there. He's right. If you actually look at the CPLR, for one reason or another, Constitution of the state, they don't capitalize state. How do you not capitalize state in this context? You capitalize the United States. It's specifically the state of New York. That's what you're referencing. It's not like the Constitution of the state of Wyoming. Or the state of humanity. It's the state. it's the noun, the state. I don't know why they did this. And this is what the CPLR says. It's just wrong. It's freaking wrong. I don't know. It's like, I'm sorry. This is supposed to be a capital. It's supposed to be a capital. I'm not wrong on this. I'm totally right on this. I don't care if everyone tells me I'm wrong. I'm totally right on this. Does everyone put it? Did he get this? Is this just one source? Did we both happen to stumble on the same source? We find the source. Results. The state. What? Let's say the state. Frankly, I would. What the hell do I know? I would capitalize Constitution too. So. All right. I'm just quoting these other people. CPLR 5601 provides an appeal be taken to the Court of Appeals as a right for oil following the state. Appellant Yearman together with Good Logic LLC and collectively which is New York United States Constitution, thus jurisdiction as a right exists. Politician, the Appellate Division Press Department seeking to protect our rights as members of the free press. Specifically, Justice Juan Merchan's unconstitutional gag orders entered against President Donald Trump and people of State of New York versus Donald J. Trump. And the foreseeable impact of wrongfully infringing on appellant's rights of freedom of the press. Appellants, members of the New York press, argue that such orders violated appellant's news gathering rights under the New York Constitution, the First and 14th Amendments, under the United States Constitution, as well as President Trump's free speech rights. Further, appellant's gag orders violated President Trump's 6th and 14th Amendment rights under the United States Constitution, as well as the New York State Constitution. President Trump was prohibited from freely communicating with the appellants and or the press about Justice Merchan's sister and wife. Many allege this created irreconcilable conflicts of interest for Justice Merchan and deprived President Trump of his rights to a fair trial. I don't really want to ball that line. No, not. The trial outcome. Material deprivation. Fundamental civil liberties. The appellate division entered a final order dismissing appellant's petition, never subsequently addressed the arguments of the New York and the United States Constitutions. Instead, this one relied on a decision of the U.S. Court of Appeals for the District of Columbia ruling against defendants. This did not comport with either New York or United States Constitutions. If I move this sentence down to the next paragraph, I save a line, I think, when the space is going to come better. No, I didn't. I guess everything worked out anyway. This did not comport with either. For example, the appellate division failed to analyze appellant's challenge to the gag orders pursuant to article, which provides some pertinent part. The expansive language in the New York State Constitution is far broader than its subsequently authored counterparts set forth in the First Amendment to the United States Constitution. As this court eloquently detailed in New AG versus Jankowski, broadest possible protections, a sensitive role gathering and disseminating news. Appellants argue that under the New York Speech Clause, the appellate division was compelled to apply the most liberal protections available to President Trump. Since President is the bare minimum of protection afforded by the New York Speech Clause, appellants argued. This is twice we have appellants argued. Let's take out the appellants argued. New York Speech Clause has obligated the appellate division to apply the approach of Sixth Circuit appeals to the issue of bar. As individuals, not the government. Thus, the Sixth Circuit robust. I won't say gives robust First Amendment protection will come within speech and the free press right to report it. This court has directly expressed that protections for freedom of reach their zenith in New York. There is no other logical interpretation. There is no other logical interpretation of this court staking New York's claim to the broadest protection. It's no logical reading of this court's there's no logical standards to the Boston. How can New York afford to attach weaker protection freedom of speech than the Sixth Circuit? New York should be proud of this court's dedication to interpreting our state constitution as the benchmark in protecting fundamental civil liberties. Appellants argue that if New York embraces the less protective approach employed by the Circuit Court of the District of Columbia, its august august promise of broad protections raise empty words, lofty ideals that have no practical effect. Accordingly, appellants understand this court's noble recognition of broadest protections of civil liberties as mandating that whenever there's a circuit split interpreting whether First Amendment rights may be infringed, New York promises to embrace whichever approach is most committed towards protecting the individual civil liberties. In this instance, that is interpretation embraced by the Sixth Circuit, not the D.C. Circuit. Instead of applying such broad protection, however, the appellate division relied on a much narrower and less protective decision of the United States Court of Appeals, the District of Columbia, with respect to the gag orders issued against Trump. Wait, so is this English? This doesn't sound like English to me now. Why does this not sound like English? Instead of applying such broad protection, however, the appellate relied on it's clumsy, that's why. Instead of applying such broad protection, however, reviewing the constitutionality. It's kerning. The part of it. A much narrower, less protected decision. That's protected the person that's the District of Columbia. It's just simpler. Said Court of Appeals decision applied a balancing test. By the United States Court of Appeals for the District of Columbia. Said Court of Appeals decision much stronger. This is much stronger. Instead of applying such broad protection, however, when reviewing the Constitution of the New York gag orders, the appellate division relied on a much narrower and less protective approach. None of such tests apply by those incompetent to the Sixth Circuit, but it is plain not keeping with consistent tradition. This they provide the broadest protection. Good. Much better. Indeed, appellants assert that the gag orders violated long-standing U.S. Supreme Court First Amendment law as well. Regarding appellate review of gag orders, the United States Supreme Court has repeated time and again, we've held that in cases raising First Amendment issues, good. Oh, this is so much better. Oh my God. I'm a freaking monster. Judge Motion had respect for his daughter as my professional. The appellants argue that the gag orders violated President Trump's right to a fair trial. Appellants assert that such conflicts of interest related to financial conflicts 6 degrees of the trial judge that's required Judge Moshan's recusal. President Trump was prepared. I don't want to not. This impacted China. How come? Deprive the public this impact improperly sentencing President Trump wrongfully deprived the public of seeing a fuller picture of those landmark proceedings. That grave impact is just the tip of the iceberg. The presidential impact resulting from the First Department's affirmation of Judge Moshan's gag order should terrify New York. You can say every criminal defendant has any type of social media platform can and rarely will use silence to insulate the court from received threats to the defendant, as with Trump, not really necessary to establish. Let's get this shorter. I'm not getting everything back in. Can I get it all back in? Will it work? Will it work? No, will it work? Is Damocles italicized? Is that a character? Or is that a book? Sword of Damocles. Okay, so first and foremost is an O. That's your first problem, Joe. Okay. I'm going to check that out. This is what I'm going to do. I'll tell you all now. This part I would not say out loud if I was on air, but I don't think it's supposed to be italicized, but I'm going to italicize it. And this is a strategic thing. The reason I want to italicize it, and I'm thinking about bolding something that he did not bold, is because I know that the initial paragraphs read the same as Ron's. And I don't want them to think it's exactly the same. I want them to know, I want to stick out a little bit. I should find something to bold here that he did not bold. This. This is what I would love to see New York do. This is a philosophically sound approach that if there were a fair court, they would actually consider. And maybe they will. Maybe they will. I hope they will. I have faith. I have faith. Yes. Let's see if you guys are talking about. On the ribbon, home menu, font block, arrow on the lower right corner, click the arrow on the window that opens, click advanced, and character spacing expanded by 1 point. On the ribbon, home menu, font block, arrow in the lower right corner. That's not it. This one. Show ribbon. On the ribbon, put the arrow on the window that opens. Yeah, all right, I don't know. This. Advanced. I think this is what you meant. But I think I remembered it anyway. So thank you. You learned something new. Also, the judge talks crap and kicks dogs, allegedly. Joe, you touched me from my sleep with a pounding on a cheap laptop key. I expect more clip. I'm sorry. Defend from good logic, access to Trump, not Trump access to the press. Don't argue this from Trump's side, from your side. You can argue all day from Trump's side, and you have to argue from good logic side. That's what I did more of. That's what I did. Because this is, well, I think I did that. When I'm saying that, that's why I say whether or not this is impact the trial outcome, improperly silencing, wrongfully deprived. Let's catch up on Soup Chat before we submit this pig. Can we do final review after waking up? I probably will. All right. Well, there you go. I'm sure you're all very busy. You weren't super chatting because you were busy throwing your money out. Go /. Well, you're just enjoying it. You're just sleeping because I was just sitting here typing. But either way, we accomplished much today. We did indeed. We accomplished much. I think this was good. I'm pleased with this. I am very, very pleased with the final work products. Save. Okay. You have to change this part here. I'll do this after I log off. All right. Let me make sure this. See if you guys need. There. Let me land my plane. It's time for the land. Can we need sleep? I'll see you all tomorrow. Same bat time, same bat channel. Plane's coming down quick. No bugs. Just no lab meat. Thank you for joining me. And I'll see you all. Godspeed.